Thank you, Chair Myrie, members of the State Senate Elections Committee, for the opportunity to testify today. My name is Michael Pernick. I'm a litigator at Paul Weiss. I'm appearing today on behalf of the New York Civil Liberties Union. My legal practice includes representing parties in voting rights and election law cases, including cases brought under the Federal Voting Rights Act. And I'd like to focus my testimony today on the voter suppression and vote dilution causes of action that are laid out in Section 17-206 of the bill. The voter suppression right of action addresses voting practices by political subdivisions that would deny or abridge the right of racial or ethnic minority groups to participate in the political process. For example, this provision could be used, as many have referenced, to prevent a Board of Elections from placing polling sites in communities that are accessible to white neighborhoods but not neighborhoods of color. It could be used to prevent boards of elections from purging voters in a manner that disproportionately affects voters of color. So these are the sorts of tools that are available under this bill that would be extremely helpful to minority communities. The vote dilution right of action addresses methods of election that dilute the votes of racial or ethnic minority groups. So, for example, as has been referenced, if there's a minority community that uses an at-large structure for its local elections, or rather a jurisdiction that uses an at-large structure for its local elections, and there's a substantial minority community that's been unable to elect candidates of their choice, they would be able to use this right of action to actually have a voice in their local government. Similarly, if there's a political subdivision, a municipality that draws lines in a particular way that dilute the rights to vote. So, for instance, if you have a minority community that's pretty substantial, but it's split into 4 county legislative districts, and they're unable to get any representation at the county level, that's the sort of racial gerrymandering that could be attacked under this right of action. Now, to be clear, these sorts of claims can be brought under Section 2 of the Federal Voting Rights Act, and we've seen plenty of that litigation here in New York State. But the Federal Voting Rights Act is a difficult piece of legislation. It's a difficult bill to sue under because it includes a patchwork of elements that have been layered on by decades of federal law. And the result that we have today is a very complex cause of action, very burdensome for parties to litigate on both sides. In order to bring one of these cases, you need a team of specialized lawyers, you need to hire expert witnesses, and to defend these cases, jurisdictions need the same. That being said, there are many municipalities across New York State that have been sued under Section 2 of the Federal Voting Rights Act. Counties such as Albany, Suffolk, Niagara, Orange, towns, Babylon, Islip, Hempstead, cities such as Niagara Falls, Buffalo, New Rochelle, villages such as Port Chester, and school districts such as Mount Vernon and East Ramapo. These cases involved years of litigation, cost taxpayers millions and millions of dollars in legal fees. For example, the vote dilution case that resulted in the town of Hempstead transitioning from an at-large structure to district-based elections took over 12 years to resolve due to the complexities in that litigation. In a recent case, it was just reported that a defendant jurisdiction would be spending over $6 million in legal fees and taxpayer dollars to defend one of these cases brought under the Federal Voting Rights Act. The NYVRA is important for many reasons, not least of which is that it fixes these problems in litigation under these causes of action brought under current federal law. It sets forth clear and predictable standards for the voter suppression and vote dilution causes of action. And it would eliminate the unnecessary burdens that are imposed by federal law on litigants on both sides. It would make it easier to address violations and dramatically reduce the cost and the burden of litigating these cases. I also want to say a word about the notice and safe harbor provision, which has been discussed somewhat in some of the other testimony, because it's a particularly important part of the bill. It creates a new mechanism for parties to resolve voter suppression and vote dilution claims without having to go to court. Now, here's how it would work. A plaintiff or a prospective plaintiff would send a letter to the jurisdiction. They'd be required to send a letter to the jurisdiction before they would be allowed to initiate litigation. And then the jurisdiction would have 50 days to just take initial steps towards resolving the potential violation. And if they do take those initial steps, they'll be granted extensions and they can have more time to try to resolve the issue before they have to go to court. This provision will prevent unnecessary litigation. It'll save a significant amount of taxpayer dollars. The provision is also important because it resolves a difficulty with litigating these cases that is somewhat unique to New York State. In other states, municipalities that are sued under the Federal Voting Rights Act often have sufficient home rule authority to resolve violations on their own without the need for a court to intervene. So this sort of mechanism is less important in some of those other states. But that's frequently not the state here in New York. For example, if you look at Section 85 of the town law, it would prevent a town that's sued over its at-large structure from unilaterally transitioning to a district-based election or some other remedy in order to address its issues. Similar restrictions exist in state law and municipal charters across the state, which make it impossible for jurisdictions to resolve violations on their own in many of these cases. So as a result, municipalities that are sued are put between a rock and a hard place. They can either litigate the claim and expend millions of taxpayer dollars in all of the expert costs and attorney fees, or they can accept that there's a violation of the Voting Rights Act, which has external consequences for the jurisdiction to stipulate to a violation of federal law. So it's really a tough decision that we put municipalities in. This provision solves those issues because it creates a mechanism for municipalities to solve violations, and it does have a standard. It has a clear standard that's laid out in the law itself. So I'll stop there, but I'm happy to answer any questions and turn it over to Perry.
So thank you very much, Senator Meyer.